compliance, but proper compliance. Step 4 is the exploration. It can be done to brainstorm solutions and can be done in the side sessions initially, but then the mediator should move it to a joint session so that both parties can participate in reaching their own solution. Again, I've already addressed most of that. You actually, if you look at the plan of a mediation, the setting the agenda, which you would think is the very first thing you do, happens very late. It's almost 3/4 through the time that you would spend on a mediation is when you set the agenda. But what happens is the first part is used for all of that emotional release and the being heard and not finding solutions, just being heard. And that's really important. That's a very, very big part of the value. And once that's out of the way and you've identified the issues, then you set the agenda. And then normally it becomes a bit more like a normal negotiation. But things tend to fall in place very quickly and very easily. And the stuff that's not going to get solved very clearly is not going to be solved. So the actual finding solutions is at the end bit, and it's remarkably short. It happens in the last quarter, and it probably takes less than a quarter of the time. Okay, step 5, the mediator concludes the process by drafting a mediation agreement or getting the legal representative of each party to do so. So that's then when you get your agreement, that then is just exactly like a negotiated agreement. You can take it to court to enforce and so on. So some things for mediation to look at: the suitability of the venue. What I said earlier, it's really important that the parties feel very clearly that they are treated the same. So your venue must be of such an extent that you don't have someone sitting next to you if someone else isn't, or close to you when someone else isn't, or two suites or a better chair or a larger chair or anything like that. You really need to go out of your way to have this absolute neutrality. You also want a place of privacy, not a busy open plan office, because the people will very often be crying in personal stuff. They'll be dealing with very personal issues. The active listening and modeling I've discussed, open-ended questions and paraphrasing. The paraphrasing is what I said, where you take the sting out of what they're saying. You say, if I hear you correctly, it sounds like you're saying this, but you just take the sting out and just go with the facts. Basically, you take the aggravating language out without changing the substance of what they're saying. Open-ended questions, you would tend to not. The moment it becomes closed-ended, you tend to guide, and you don't want to be leading at all in mediation. Then reframing, but typically should not give legal advice. That's similar also to your reality testing, where you say, okay, they've sort of at the point of an agreement, and then you start testing, is this sustainable? Is this something we can do? And you can give what-if scenarios where you're actually asking them questions. Again, be careful that you're not making an argument through it, but that you're actually just having them test if they can really commit in a real way to what they're apparently committing to. Okay, mediation can work well where the court cannot provide the relief that the parties need. You've got interpersonal problems between friends. The court's typically not going to get involved with that. The parties wish to settle promptly. Mediation can be incredibly quickly because you can arrange a mediation and see the mediator within an hour. There's not awful lot of preparation on the mediator side. So it can be an incredibly quick way to do it. Minimize costs compared to litigation, certainly not necessarily to negotiation. Voluntary compliance is desirable. Again, with most relationships, there's a point of voluntariness, and mediation doesn't make people feel forced into something. They feel it was their choice. So it doesn't damage a relationship in the way that the others do. And it can actually build a relationship in many ways and teach good future skills to the people simply through the process itself. The parties wish to avoid a court precedent. That's similar that you'll find with all the other ADR systems as well. The parties have difficulty negotiating. So you've got people who are not necessarily, it's something that they could normally negotiate, they just don't have the skills. Then mediation can very easily teach good negotiation skills, ironically. The next one is exactly the same. The parties assess the facts differently. So they disagree on what happened. Now, the benefit of mediation is what actually happened is actually taking a bit of a back seat to the relationship and how the parties feel and the way forward. So if that becomes a sticking point, mediation can help you sidestep that to some extent, unless one party is absolutely adamant on sticking on their version and needing that to be acknowledged, then mediation won't work. The parties have a continuing relationship, most family matters and such, and the parties want to maintain confidentiality, similar with arbitration. So where mediation is typically not appropriate is the party or parties cannot represent his or her best interests. And that's because mediation, you can have lawyers present, but you're not going to mediate through lawyers. So the party is going to speak for themselves. And if they can't do that properly, that's again the power structure as well. Mediation might actually be damaging to one party. The client wants a court precedent. Clearly, then you're going to have to do litigation. Where issues of status are involved, that's simply because you can't mediate it. It has to go through a court. Cases where wills are being contested, okay, that generally doesn't work well with mediation. One of the major parties is unwilling to mediate. Again, it's voluntary. If one person, even if the court says you must mediate and one party is absolutely unwilling to do it, you're not going to reach a successful conclusion. One party adamantly denies liability, that I already addressed, and one party is likely to go insolvent. That's for all the insolvency implications and results in law that mediation isn't well suited to address that. Okay, we're going to do our tricky role play next, and I think instead of dividing into groups, I'm basically going to need 5 volunteers. So it doesn't matter which group they're from. So I need 5 people to, in the chat, indicate to me that they're willing to volunteer. I'll give a minute or so for that. While that's happening, I'll play the other video key I wanted to show you. That's very relevant here. It's a humor as well, but it's about that listening aspect versus finding solutions, which for some people is really, I know it was for me, really difficult to understand. It doesn't make an awful lot of sense that someone is telling you their problems if they don't want you to solve it. But it's certainly true, and with mediations, often trying to solve it can actually make the problems bigger, because what the people want isn't a solution. They want validation and to be heard, really, more than anything else. Okay.
It's just, there's all this pressure, you know? And sometimes it feels like it's right up on me, and I can just feel it, like literally feel it in my head, and it's relentless. And I don't know if it's going to stop. I mean, that's the thing that scares me the most, is that I don't know if it's ever going to stop.
Yeah. Well, you do have a nail in your head.
It is not about the nail.
Are you sure? Because, I mean, I'll bet if we got that out of there.
Stop trying to fix it.
No, I'm not trying to fix it. I'm just pointing out that maybe the nail is causing.
You always do this. You always try to fix things when what I really need is for you to just listen.
See, I don't think that is what you need. I think what you need is to get the nail
See, you're
out.
not even listening now.
Okay, fine. I will listen. Fine.
It's just, sometimes it's like there's this achy, I don't know what it is. And I'm not sleeping very well at all. And all my sweaters are snagged. I mean, all of them.
That sounds really hard.
It is. Thank you. Ow!
Oh, come on. If you would just.
Don't.
Try to see things my way.
Brent, I see you've got a note here saying you've missed large chunks of audio. Was that from the lecture or just from the videos?
Maybe it's the nail, Brent.
From the videos. Okay, the rest of you got audio from that, right?
Yes.
I can
Yes, sir.
send you the links if you want, but they're not crucial. It's
No, we
mostly
could perfectly hear it.
the videos are mostly humor in between, and it's a good way to remember. I personally battled quite a bit for a long time. If people come, then you want to give them a solution, and that's very often really not what they want, and it doesn't make a lot of sense, and you forget it. And a humorous little video like this often helps you to remember. It's like, okay, yeah, it's like the nail. Just listen. So that's useful. And particularly mediation, whereas a mediator, you do an awful lot of listening and a little bit of facilitating. Okay, I need the 5 volunteers because so this will be our last role play. But yeah, as I said, we need 5. I'll read. I haven't gotten volunteers yet, so I will read the general instructions, and then if I don't have volunteers at the end, I'll just randomly pick people. Okay. So the general instructions that everyone has access to says the following. Global warming Axel and Mary Claire got married in 1999. In 2001, they quit their jobs. They were both working for an international headhunting firm in the US, and together started a business in Luxembourg called Ozone Agency SA. The company operates in executive recruitment, placing people experienced in the climate change, corporate responsibility, and sustainable development fields, and Ozone is the only niche recruitment firm in this area of expertise in Europe. In 2001, it was just the two of them working from their own home in Luxembourg, but the business started growing immediately, and they now have a staff of 40 and have just moved into a new expanded office in the center of the city. Ozone Agency's clients include many of the leading companies in Germany, France, and Benelux, plus foreign multinationals, and they now have a database of 10,000 people working in this professional field. Turnover has been increased by an average of 20% per annum and now stands at 20 million euros of billings a year. Axel and Mary Claire each own 50% of the business. The gross profit margin is 10%, and each is expecting to collect 1 million euros in dividends this year, much of which they reinvest. Blue Sky Green is an American recruitment agency based in New York, but with offices in London and Copenhagen. BSG is wholly owned by a Monaco-based private equity group called Mamma Mia, who bought BSG 2 years ago and have been investing and expanding its business by 50% each year. BSG is a general recruitment firm specializing in senior executives, but make their money mainly from searching for and placing executives in corporate affairs, PR and lobbying departments of international corporations. Mamma Mia's owners are former insurance brokers Marta and Martin, who have been in partnership for over 10 years. Together, they also run BSG. Mamma Mia have assets exceeding 2 billion euros and numerous investments and shareholdings in many service fields. Marta and Martin approached Axel and Mary Claire. They said they were interested in expanding BSG into the areas in which Ozone is operating and to do so on a broader geographic basis. They asked if Axel and Mary Claire might be interested in having a discussion about folding Ozone into BSG, and if so, whether a meeting to explore the prospect might be in order. Mary Claire replied saying they always listen to serious proposals and would be happy to meet, but that at present the Ozone business was going very well and selling out was not top of their agenda. Martin responded that dialogue is always a good thing, even if it led nowhere, but when exploring options for mutual gain, it often helped to engage a neutral person to facilitate discussions. Martin said he knew from Mamma Mia's lawyer that there was a very good expert independent deal facilitator, and asked Mary Claire if she and Axel would agree to take this path, and if so, share the cost of a top facilitator for a day. After consulting their separate lawyers, Mary Claire and Axel agreed. The meeting is about to take place in a hotel with a deal facilitator chosen by the respective lawyers. Axel and Mary Claire attend with their joint lawyer, and Marta and Martin attend with their lawyer. So I'll point you to the detailed facts again, but what we need is the 5 roles, each of which will have additional information that's not available to the others. And the 5 roles we're looking at is one set of business owners is the one. The other set of business owners is the second player. Then the lawyer for the first set is the third player. The lawyer for the second set is the fourth player. And then the facilitator is the fifth player. So that's what I'm going to need just a few volunteers on. Still no one. Okay, let me just see if I can. Okay, Louis says, I can't volunteer due to internet, but I can try. That's fine. You can try. Maybe, do you have a specific role you want to volunteer for? Seeing that you're the first volunteer, and maybe let you pick your role. Make me the lady. So there's no lady. There are two. So the one group is Axel and Mary Claire, and the other group is Marta and Martin. So in either way, you'll be a combination of a husband and wife. So it's really about, do you want to be one of them, one of their lawyers, or the facilitator? I'll be one of them. Okay, so I'll make you Axel and Mary Claire. Any other volunteers? So let me just put it in here. Okay, let me just look at some random names then. Carla Smith, are you there? Okay, looks like Carla is not present. Oh wait, there's a message, let me see. I'm here, but my mic is not working. Okay, Carla's mic doesn't work. Hopefully that won't be the problem everywhere. Emma Efstratio, I hope I said that correctly. Are you here, and does your mic work? Having the same problem. I hope this is not going to be everyone. Herman Ice, does your mic work?
Yes, sir, my mic works.
Okay, can I turn you into Marta and Martin? Would you be willing to take that role?
Sure. Yeah, no problem.
Yes. Thanks, Emma. I see you say you can do it over the chat. It's going to be a bit difficult. Though. Louis says he wants Francois as his lawyer. Is Francois willing to volunteer as a lawyer?
I don't mind, but I think me and Malabugeng participated
already.
I would like to offer the opportunity to our other learned colleagues as well.
That's true. How about Katlejo Sebande?
I'm here.
Would you be willing to be the lawyer for Louis?
Can I rather be the facilitator?
Sure. You want to be the facilitator? That's fine.
Mm-hmm.
That's the more difficult role actually. But
oh wow.
But if you volunteer, poor Louis, he's saying, "Wow, you'd rather be the facilitator than his lawyer."
I'll be Louis'
he seems
lawyer,
to be taking
then.
offense. Okay, you want to be loyal? Wait, no, I've messed up that chat. Okay. So fine. So Katlejo Sebande is Axel and Mary Claire's lawyer instead of facilitator. Okay, now we need a facilitator and one more lawyer. Nkulu, oh, I'm going to battle with this. Nkulu Leko, Nkosi. Are you there? Okay, how about Prudence Mate? Okay, so Nkululeko also has troubles with the mic. Prudence? Here I just need access to the mic, please. What do you mean access to the mic? You should be able to speak.
Mr.
Does your
Rogier?
mic? Yes, I can hear.
Yes. Can you have your volunteers? Maybe I can make them all presenters, just so that we avoid the mic issues. Don't know if it's possible.
Yeah, I'm not sure. I mean, I don't have
Yeah.
a problem with it.
Because I tried to ask, is it Emma? But she's not typing. I wanted to find out what is the issue with the mic. Then I can make her the presenter, and this Smith as well. Then yeah, they can take it from there.
Okay, so yeah, if we can do that, that would be great, because we just need two more.
You just need 5. No.
Yeah, so I still need a lawyer for Marta and Martin and a facilitator.
Louis, are you are also a presenter? You are able to make them presenters, those who volunteer,
Oh,
correct?
okay. I didn't know I could do that.
Just check if you
Okay, hold on.
if you
I'm not sure if the mic problems are on this side or on their side. Emma
on
says
their
it doesn't
side,
go on.
would
Yeah,
be
no,
nice
I
to make.
can't make them presenters. I think only the organizer can do that.
Oh, okay. No, but I can, so it's fine.
I will say
Yeah.
I don't suspect that would be the problem, because there are other people here who are not presenters who can use the mic. My
Yes,
guess
I
would be the
noticed.
problem. The problem would be
With their,
local. They didn't
yeah,
give permission to the web browser, or the mic is broken, or it's not set up or something.
okay. So it I cannot be of assistance. It's fine.
I
Let's see
appreciate
if you
that.
can get other volunteers with working mics.
Okay, so Savannah, I'm just picking random. I'm spinning the mouse wheel and seeing where it lands.
I am here,
Savannah,
sir.
would you be willing to be a
I'm here.
facilitator or a lawyer?
I think I'd rather be the lawyer.
Okay, so make you the lawyer for Marta and Martin. Then I just need a facilitator still. How about Tsepo Ben Mabasa? Okay, nothing there. I don't know if I say this right, but Mignan Rustov?
Can you hear me, sir?
I can. Would you
Okay,
be
yes.
willing to be the facilitator?
Yeah, I can try.
Okay. So now we've got our 5 people. So you'll need to look at the facts again. Everyone will have to do this actually, but you 5 must please not look at any facts other than your own, right? The others can look at anything. That doesn't matter now, because they'll be observers and hopefully contribute after the fact. So let me just find your different roles for you. It's on the handout, the thick booklet. So the general instructions for everyone is on page 4 and 5, so everyone can read that. That's the stuff I already read to you as well, but you want to see it again. Then Louis, your facts are on page 7. So that's what you have to look at specifically with your instructions. Then who's next? Next is the lawyer for Marta and, yeah, it's not the lawyer yet. It's Marta and Martin. So that's going to be, who did we assign? And that's Herman Eis. Your facts are on page 9.
Sorry, sir. Am I for Marta and Martin or the lawyer for Marta?
No, you're Marta and Martin.
Okay. Sorry, what page?
Page 9.
Okay, thank you.
And then there is, so if you want, yeah, it's going to be difficult because you're not necessarily in the same groups. I wanted to allow you to speak to your lawyers, but it's fine. The instructions should be sufficient. So then the lawyer for Ozone Agency, that is Axel Martin's lawyer. That is Katlejo. Your instructions are on page 11, but you also have to read the instructions on page 7. So you have to read the instructions on page 7 and the instructions on page 11. And then the next lawyer is Savannah. Your instructions are on page 13, but then you also have to read the instructions on page 9. So
Thank
13 and 9. And then Mignon, your instructions are easy. They're on page 15. So I know some of it would have a bit of detail you'll have to make up as you go. You can actually ask me questions if you want on some of it if you're unclear, which the others instructions should be fine. But if you've got some questions on yours, you can ask, and you can ask it in the big group. It's fine. Okay. And let's prepare on these until 1:30. Let's take a 10-minute break until 1:30. That'll be quite a quick reading, but it should be fine. And then 1:30 we're here again to do the exercise. Then we move to arbitration. We might even be done by very shortly after that. I don't want to link to a time, but we'll be done before 3 certainly. If you want a bit more time for this exercise, we can easily accommodate it, but I think 10 minutes should be fine. Then when we get back at 1:30, if you have any questions, you can ask, and then after that we'll do the exercise. Thanks. Katlego, your mic is open. Okay, I think that should be enough time there. Does anyone have any questions before we run this exercise? Okay, it seems not. In that case, Megan, you're free to start, and yeah, see if
Thank you,
you
sir.
each can do what you're here to try and get.
Thank you,
Floor
sir.
is yours.
I just quickly want to give a disclaimer. I do have 5 dogs, so if I'm talking and they start barking, I do apologize.
That's fine. Thanks.
Okay. So I will then start. Since it was Marta and Martin who suggested the discussion, I propose them to start. Or invite them.
Okay. Basically, we are the business owners, both Martha and Martin. Both Martin and I are the business owners of I accidentally went for Martin, so ignore me. Never mind.
I'm also a little bit confused. I'm like,
Yeah, sorry, I'm
is
for
it not
Alex and
Axel and
Maria.
Mary
Ignore
Claire?
that.
Yeah, sorry, I was also confused. I think I'm Marta and Martin. I'm correct, sir.
I think the roles I placed in the chat, because I don't know all of your names. Let's just check. So what we have is for Louis as Axel and Mary Claire, for Herman as Marta and Martin, for Katlego as Axel and Mary Claire's lawyer, Savannah as Marta and Martin's lawyer, and Mignon as facilitator. Is that how you have it?
Yes.
Okay. So would you need another minute or so before you can do this?
I don't know, I'll try it, sir. I think I was thrown in the deep end here.
I think everyone was. That's fine. Okay.
Let me just check here.
For what it's worth, it's a reasonably complicated set of facts for an exercise, but the focus is really on the facilitation. You know, and the seeing what works and what doesn't. So it's not so much about the specific conflict.
I'm just trying to see how I'm going to start this. Because I'm trying to get their company, basically. That's what I understand. Or to absorb them.
Let's give you 2 minutes, and then just indicate to Minghan when you're ready, and then you can start. You don't have to wait for me, but take the time to just make sure you're ready. Then just give her an indication. You can proceed.
Okay. So I just want to make sure, am I supposed to like pitch, make a pitch here?
Yeah, so you've got your lawyers as well. They should know when they're supposed to jump in, and the facilitator can make use of the lawyers as well. She can also refer to them if necessary or get their input. But yes, you're basically, you're seeing if you can find a deal. So it's not technically a mediation, but it follows the same process. It's a facilitated discussion. So it's close family of mediation that follows the same structure and same principles. Does that make sense?
Okay, yes. Okay, with your with ozone expanding, I would like to absorb them. and I would like to make an offer of, let's say, 50 million pounds. As an example, I bought the BSG, and it's worth 5 times more now than it was before we took it over. So I think there would be a lot of advantages for you if you let us absorb you or take over.
You know, Mr. Martin, I'm not really that interested in selling. How is your employees being treated at BSG? Have you grown your employees? Is there a lot of retrenchments? Have the regional staff remained? What's happening? Give me some feedback on your employees.
Mostly the regional staff stayed, but we did put some experts in to help manage it better, as to expand it. And with the speed you are expanding at currently, someone else is going to take over, and it might not be in your advantage. So
I don't think someone else is ideally going to take over unless we actually want to sell it to them. But I'm not going to argue that there's not competitors in the industry. A lot of the climate change industry is expanding at an exceptional rate. I'm sorry, I need to at an exceptional rate. What can BSG offer us? Why, other than money, what's the incentive for us to sell?
I can help you expand 20% more in the next 3 years, basically.
Maybe my lawyer can advise if it would be feasible for ozone agency to even be acquired.
Ozone agency can be acquired, which is going to be dependent on what's his name? Mary Claire and Axel, if they decide to sell the company to Mamma Mia.
Okay, Mr. BSG owners, what is your offer for ozone agency? You have had chance to look at our financials. You've had time to consider the fact we've done the due diligence. What is your offer?
Well, the highest we can go is 80 million pounds, because we would have to invest another 75 million to open up a string of ozone branches in the US, Japan, and other parts of Asia. So we would have to invest even more money after acquiring you.
Will myself and Marie Claire remain with the company, or are you taking it over completely?
No, you will remain with the company. We'll just try and manage it so as that it's more profitable.
And what would our share allocation be in that regard? How much percentage of the company would we own upon acquisition?
Ideally, we would like the majority share, but I guess we can negotiate.
So you're aiming for about 60-65% of the share of the company, while we retain 40 or 35%.
I'd rate so, yeah. I mean, just a majority share. Yeah.
And you're offering 80 million euros for the 65% more or less.
Yes, because we're gonna have to, like I said before, we're gonna have to use another 75 million to open up a string of branches of Ozone.
What if Axel, what if myself and Marie Claire wishes to distance ourselves a bit more and say that you take over 100% of the company in return for 120 million euros? So that would give you complete and ultimate control of the company.
That would be a bit difficult, seeing as we have to put in money further in order to expand it.
You see, my main priority is to make sure that the staff that is currently at Ozone Agency retain their jobs. Let's meet each other in the middle and say, if we'll relinquish 80% of the company to you while retaining a silent partnership of 20% for 90 million euros on the condition that you retain all the regional staff for a period of no less than 4 years, unless given that their performance is subpar.
Okay, let me just maybe my lawyer can see whether it's a good idea or not.
Yes, so you see the biggest threat now to Mamma Mia and BSG is non-action. So they see an opportunity now in the market, and they are very well versed in the industry. You know, they have the tools to not only grow Ozone, but to grow it internationally, which is something that maybe wasn't there before. And currently in the market, the focus is on sustainable development and climate change, and this is very costly and risky, you know, if you aren't already well versed, like Mamma Mia and BSG already are. The initial offer of 50 million was taken into account the investment cost that we will have to incur of 75 million in order to bring Ozone onto the international stage. With regards to the share of ownership, I think a healthy share would be 80-20, 80 to us, 20 to you. And that would mean for you in the next 3 years, you'd get an additional 40 million as a result of us taking over your operations. And we plan to acquire Ozone as is because we see it as a successful company already. We see it as something, you know, to be developed, to be added onto. So there's no reason for us to make you feel like we would cut employees or cut costs or do anything like that. So I stand with my client's offer, and it's just now about what you're willing to offer in return.
You see, the problem, Miss BSG lawyer, is that you initially offered, I think it was 80 million in the beginning for 60 to 65% of the company. Now it's been lowered to 50 million for 80% of my company. It feels like there seems to be a lot of contradiction
No,
between
The original offer was
the original was 50
It was 50 million.
and then
yeah,
there was a little bit of back and forth, and then we
final
upped it
80.
to 80.
I
Because we
just
do
don't
see the
feel
potential.
comfortable with 50 million for 80% of the company. I think I'll be
That's why we
comfortable.
revised it up to 80.
Yeah. So it's 80
The
million
initial
for
was
80%.
50. Yes, that's correct. Because as we said, it would cost us an additional 75 million. You know, we have to pump that into Ozone to get it on the international stage. And that's obviously a huge cost, yeah.
Do you think we can take maybe a 5-minute recess just so I can consult my lawyer in private?
Sure.
Cool. 5-minute recess over. Lawyer, please take over and say we accept it.
All right, we accept the offer of the 80 million for the 80% of the shares. We also like to state, as my client has already stated or indicated, we also want to transfer the employees in terms of Section 197. Would you be able to absorb the employees as per Section 197?
Yes, that sounds agreeable. Let my lawyer just see whether my lawyer agrees.
Yes, we definitely do have the capacity to do so. We'll acquire the company as is, with 80% share going to Marta and Martin, and 20% going to Axel and Mary Claire.
All right, I believe that we've reached an agreement. I don't know if the facilitator can step in.
It seems as though if both parties are happy with the offer that was made, then perhaps they should come together in their private time to sign formal agreements to that effect, and then I think we can convene this meeting.
I agree.
Agreed.
Okay. So that again went remarkably well, all in all. Maybe just from the participants, is there anything that you feel from your instructions you didn't accomplish, or that you don't think went well, or that you think could have been helped by something either you or one of the other players could have done more, less, or differently?
From Axel and Marie Claire's side, I think we did very good to get the point across that we want at least a proportional share in the silent partnership, so we can step away, if we want to go on with our private lives. Our lawyer was honest and made sure to keep the employees, as that was the important part for us. But other than that, I think that we did very well.
Okay, thanks. Anyone else? From the participants first, including facilitator, if she wants to say something. Yeah.
I think we we were trying to pay a certain amount and not go over it, and I think that was accomplished.
So we had quite a large overlap in what was possible for an agreement, though there were non-monetary considerations like the employees and the walking away and so on. But yeah, all in all, it went really well, I think.
Just from my side, sorry, as the facilitator, I think I jumped into it a little bit too quick. I understood that I must get them to each say their part, and then I need to introduce what we are talking about. But looking back at it, I should have actually introduced what we are talking about. I should have said that the goal of the meeting is to determine whether Mamma Mia or BSG and Ozone Agency can make a deal. And then I should have expressed my neutrality and my impartiality. So I think I jumped the gun there a little bit.
Yeah, I agree. I think you came in a bit blunt in the beginning. I think it worked well in this case, regardless. But yeah, if you've got a slightly different set of facts, that might have led to you might have hit a brick wall with people just sitting, like when I ask for volunteers, everyone just sits quiet. You might have hit that sort of situation, but it went well in the end anyway. So I don't think it was a disaster.
Yeah, I also think so. I think at the end I was neutral and impartial because I didn't really say much.
Yeah, well, they were happy to speak, and you probably found that this is an interesting thing. It probably takes more energy than you think, and this isn't even what you will normally get with all the emotional energy. But even though you're pretty quiet, you have to be on top of everything that's going on. at all times, and that's probably more tiring than people generally anticipate. Anyone else? Either participants or just from the rest of the class?
I think that the facts for Mamma Mia and BSU were super confusing with all the percentages and money and billings and all that stuff. So I think, you know, it really shows how you really have to have a good line of communication with your client to know what's actually going on, because there's so many, like millions, in this paragraph. So
yeah, to be fair, I'll say that in reality, you would have a chance to speak to your client and so on, which you guys didn't have here. And I said the facts are reasonably complicated for an exercise. They're probably pretty simple for a real commercial deal. But for an exercise, they're reasonably complicated. And we didn't take a lot of time on this. But yeah, I think it went well. Anyone else?
I would also like to say I respect the facilitator's self-reflection regarding her participation. It's always important to start off with the rules of engagement. And then secondly, you said something earlier on that's staying with me, and that is that you must always find everybody's interests. So I feel that Louis' team was the ones that was in a stronger position there. And BSG could have perhaps inquired more about what their interests were. And then they would have, for example, I had the opportunity to read through everything now. So I've got this now in hindsight, which they didn't have, obviously. But they would have pressed the relationship situation between the two of them and perhaps made more inroads and gotten a better, sweeter deal at the end of the day.
And look, there was certainly a lot of room in if a negotiation goes like this, there's a lot of room for people to engage further, because there were not really a lot of give and take. There was a little bit of horse trading, but by and large, they found each other pretty easily. So, there was certainly room for more if you wanted. But it also brings up a good point, what you're saying. It would be interesting now, after the fact, for the participants to read the other instructions that the other people had, to be in the same position you are, where they could see everything. Unfortunately, in real life, you're going to miss things, and you're not going to know what you missed because you don't have this opportunity to go look at things after the fact. With negotiation, that actually becomes important. If you get it's a jump to negotiation quickly, not so much mediation now, but if you get a deal that you really want and that you're very happy, it's normally a good idea to not show too much how happy you are immediately. Take a moment and take time to think of it and then accept it. And the reason isn't specifically just for this negotiation or for reputation. It's actually that you don't want the other side to sit with buyer's remorse. If you're too happy or too eager to take a deal, they immediately think, I could have gotten more or I could have done better. And that buyer's remorse might create, again, an undermining of the stability of the agreement. So there is an element of, for better or for worse, to have a bit of a poker face with offers that you accept or reject. Anyone else? Okay.
I'm very disappointed in Alex, the gambling addict.
Well, yes, that's off script, but not off script, off the main topic. But yes, I get.
Well,
what
it
you're
says he
saying.
has a gambling debt of £2 million, or 2 million euros. So I feel like it's important.
Sure.
Maybe I should have sold the company for £3 million and get him away from us.
Just get rid of just outsource the problem. Okay.
Yeah, Alex could be someone else's problem.
If there are no other comments, I'm going to quickly finish up with the mediation and then do the arbitration. You're again welcome to have comments, and I'll be, after we're done with everything, I'll be around for a bit for anything anyone wants to ask specifically or go into more detail or look at again. Okay, so the quarter next mediation rules, you'll see they're on page 17 plus of your handout. That's the thick one. Okay. But the process basically follows the following step. Now, these things change, etc., as you know, with the rules, and we can't do a full civil procedure here. But for your guidance, what you'll find is you start with requesting a mediation that you'll find in rules 75 to 79. Then the meeting to mediate is addressed in rule 84. Drafting a mediation agreement forms part of the request to mediation, really. So that's rule 77. That should have been up higher. Sending a statement of claim and a statement of defense to the mediator. Now, that is specifically in the court annex mediation rules, and that's not something you would necessarily always do in a mediation. In fact, in most non-legal negotiations, you won't do that. That maybe formalizes it a bit too much. It's sort of like a claim and a counterclaim, or a claim and a plea. And you definitely don't want it to come across like a claim and a plea. You don't want to get into that adversarial mode. So the statements would be, you want to word them in a way that still allows the relationships to benefit from the mediation process rather than litigation. But because it's court annexed, you're clearly dealing with a sort of matter that will go to litigation. And it's the type of matter that can be litigated. Otherwise, you would just have been in a normal mediation, not a court annexed one. It then addresses the mediation session specifically and finalizing the dispute where there is agreement or where there's no agreement. And where there's no agreement, it's very similar really to the CCMA process. Where there's no agreement, there'll be a certification and then it can proceed to the litigation. Okay, any questions on the mediation in general? Okay, so arbitration, this is the easiest one of the bunch because it's incredibly similar to litigation that you're used to. So arbitration is a formal process where a third party is empowered to make a decision when two parties in a dispute. Now, one of the differences is with a mediation, you sometimes have the parties determining the process, but very often you might have a set process, but the parties determine the outcome. So this is the process you follow, but they decide on what they want. Arbitration in that sense is sometimes the opposite, and it's in that way different from litigation as well, in that the parties can very often determine the process, but the substance, the decision is made by a third party. So in some cases, you'll be locked into an arbitration agreement or say the rules of AFSA or something like that. But in other cases, you select the arbitrator, you select the process. It's just the actual decision that's out of your hands. So in that sense, those two are opposites. And of course, depending on what you need the most control over for whatever reason, that might also be a consideration. So importantly, we've actually already addressed a lot of this. It's confidential, and that's one of the main reasons businesses really like arbitration. It's relatively speedy, which is, it's got a cost factor, right? Because it's not just, is it cheaper or is it more expensive? It's about the opportunity cost as well. And I think you know what I'm saying with that, but the opportunity cost is the day, the week you spent in court or drafting pleadings, you could have spent making money, and commercial aspects that could be significant amounts of money. You could talk about millions in a day. So it's not just what does the arbitrator or the court cost you, it's also, you know, the time and the opportunity costs. It allows for a decision maker with specific expertise. We discussed that. That's one of the reasons the building industry really likes using arbitration. It's voluntary, but once agreed to arbitrate, that agreement is binding even before a dispute arises. So you're generally not forced to arbitrate. There are some exceptions like the CCMA, but generally speaking, you opt into arbitration, but mostly you opt into arbitration before a dispute even arises. You'll enter a contract, and so many contracts will have a compulsory arbitration clause. And very typically in South Africa, it will say an arbitrator appointed by AFSA, following the AFSA rules, or something similar, and then some determination of who pays the costs. Even on software now, though, if you look at international software, they will have arbitration clauses that require an American arbitrator, and often the companies would offer to foot the bill of the arbitrator, which opens up just a whole bunch of strategic thinking by itself, and you can write an entire article on that. Probably not terribly useful to go into details here, and probably in many cases not useful to your long-term reputation, but still viable. Okay. There's no right to appeal, though review is possible. We've addressed that. Disputants can typically select their arbitrator. And again, this is one of the most important things. Often they've got very convoluted ways of selecting the arbitrator. So you'll have either the chairperson of the LPC has to indicate it. Well, I don't know about the LPC. It used to be with the Law Society. Has to select the arbitrator, or the chairperson of AFSA, or of whatever arbitration foundation there is, or organization. Or what you often get is, particularly transnational, is each party has to appoint an arbitrator, and then these two arbitrators meet and they together appoint a third, and then you've got a panel of 3 arbitrators that's selected by this process that everyone then presumably accepts, and they make a decision. That gets quite costly, though, to have 3. So the typical arbitration process, there's an Arbitration Act that determines that it's binding and some of the process, but it really allows for a lot of movement outside of these determinations. These are just, it very vaguely and basically sets out some aspects. Okay, agreement to arbitrate must be in writing. Okay, it must identify all the parties. It must define the dispute. For the parties, the agreement doesn't have to define the dispute, but the parties must define the dispute clearly, and they must clearly define the powers of the arbitrator. Now, normally the arbitrator makes a decision that's binding. That's almost in the definition of arbitration, but you can actually do advisory arbitrations. You can ask an arbitrator to make a decision that would not be enforceable. Now, why parties would want to do that is very often actually as part of a negotiation, and they hit an absolute brick wall, but they don't necessarily want to litigate, but they also don't want things to become public, and now they need to find out what's going to happen, and they get an arbitrator to make an advisory award that basically gives them an idea of what would happen in court, or how would a third party see it, and that could often move them towards an agreement. So you do get non-binding arbitrations. It's just the exception, not the rule. So arbitration agreement should provide for the appointment of a specific arbitrator, or at least an identifiable arbitrator. As I said, it might even have who appoints the arbitrator or who selects the arbitrator, but it must have something like that. Specify how the proceedings will be recorded, and that's either in writing or not at all, or by tape or on video. It doesn't have to be recorded in all cases, like court proceedings should. And of course, if it gets to things like POPIA, it becomes important to bear in mind what you want to keep or not, but you also want to bear in mind the fact that it might be reviewed. And if you don't have any recordings at all, the review might be really difficult and you might run into difficulties. So you'd probably want to record it, but not keep the recordings for longer than you would need for purposes of a potential review. Okay, specify the procedure to be followed. Again, with arbitration, you can pretty much make up your own procedure. Make provision for interpretation if required, same as court, and specify when and what form the arbitrator's award should be given. It actually does provide for timeframes, and the Act, and it actually allows for arbitration to move reasonably quickly. I think you've got timeframes that move in the area of 30 days and 60 days rather than 3 years and 2 months type of thing. So you're not quite on labor law time frames, but you're quite a bit faster than what you would expect normally from civil court. Okay, steps of a typical arbitration. pre-arbitration, this is very similar to a trial again. You start with a housekeeping, postponements, points in limine, and the pre-arbitration is really a meeting where you determine everything, where it's going to be, and you make sure you're on the same page on everything on the arbitration. The opening and narrowing of issues would be very similar to your initial pleadings and discovery and your pretrial conferences. And then steps 3 to 5 repeat until the commencing party has called all its witnesses. Thereafter, the opposing party gets a similar opportunity, and you'll immediately recognize that you've got evidence in chief, cross-examination, re-examination. So you just follow that like with litigation. And then you've got your closing arguments and writing of an arbitration award. So you'll see it's really almost indistinguishable from litigation. Your differences are that you can change the process, you get to select your arbitrator, slightly faster timeframes, reviewable, not appealable, and you've got the confidentiality, which is huge. That's a huge thing. So what are the pros and cons of arbitration? I've actually probably kind of ruined that exercise just now. And that is, in theory, the end of the theory. So there's then, let me just make this thing not share anymore. There's then an exercise, case study, right, in the book on page 25. And this is a case study you're supposed to take and write an arbitration award on and say how you would conduct the arbitration. Now, if you draft this arbitration award, that will take you about 2 hours, I think. And then there won't be really an opportunity for feedback on that. But we could talk about how you would conduct the arbitration, which I think we'll do right at the end. And then there's another role play, but that role play is so mingled up that it's not going to work. It's not going to work on this forum or on this medium. So the last exercise will be that one of how will you conduct the arbitration that starts on page 25. But before that, I just want to check on everything we've done so far, literally anything on it or anything related to it. Do you have any questions or lack of clarity on anything at all? Or just comments, or I don't want you to feel something hasn't been clear enough for you. You're not necessarily expected to be able to do all of these things, but you're supposed to understand what it entails. You're supposed to be able to compare them to each other, to know where they fit in, and to be able to tell a client about the options and broadly at least explain to them what they could expect if they follow these procedures. The actual
if I may ask a question,
is a long thing. Sure.
Mediations as well as arbitrations. One arbitration I had to be in was very expensive with regards to the venue. Is it possible, especially now after COVID and all the rest, to have it online as well to reduce costs?
Yes, you can. In fact, particularly mediations had a lot of discussion around it with the lockdowns, and it became an entire field, online mediation. I will say that it's not ideal. Okay, and I'm a big fan of technology, and I'm normally happy. I was very happy to do the labor law online, but for the same reason that this class is difficult to do online, it's even worse when you do the actual mediation or the arbitrations. The reason for the arbitration is the normal things where you've got your testing of witnesses, but that's the same as your online court cases, which we do. You know, it's not ideal, but it's certainly viable, and we've been doing it. And some of it is even more convenient because the roles are, time management is easier and so on. With mediation specifically, there's the aspect of modeling that I discussed, and because it's so much a body language and being there and being heard, it really loses a lot from an online mediation. So for mediation, even though you could do it online, I would push very hard for in-person, Arbitration would be much like what you would find with litigation. It's not ideal, but it's perfectly viable. What you would have to look at, but you'd have to look at that anyway, is your POPIA implications, the security of the data, where it goes, when you host it, how safe is it, interception, etc., etc. And particularly so because in a court case it's public record, but in an arbitration it won't be. So you would have a lot more kicking in on you than would in the case of court process. Court process also has specific exclusions in POPIA, which wouldn't be applicable in all cases of ADR. Does that make sense?
It makes a lot of sense. Thank you.
Okay. Anyone else? Okay, so the last exercise, read through the case study, page 25 and 26. And you'll see that it says there's a task for handing in 2 weeks. I'm not going to be taking any tasks in 2 weeks. I don't think you'll be handing in any tasks in 2 weeks. And writing the arbitration award is certainly a worthwhile exercise, but it's also not something we can do here or, frankly, in most cases in class if we're not in a continuous contact setting. But what we can do is do a quick discussion on how you would conduct the arbitration. So I'm going to ask that you read through that quickly. Then at 20 past, so it's 7 minutes, 20 past, we'll do a quick discussion, and half past we'll be done. And then I'll be around for questions for anyone who wants, but then anyone who doesn't have questions, there's then nothing more for me to teach you from this by 2:30. Is that reasonable? So we'll please read through that. 7 minutes, just be here at 2:20 for the last 10 minutes of formal, and then we're done. Thanks. Okay, is everyone done? Just give me some indication, someone, if you managed to get through all the reading. I'm guessing most would have. Can you hear me?
Oh, yes, we can.
Okay. So that should have been more than sufficient time to go through that. So just as an arbitrator in this case, how would you conduct the arbitration? You pretty much have the facts. You've got an idea how this would play out. But how would you approach an arbitration like this? And as a tip, you can really approach it very similar to you, the way you would do litigation. Your problem is very clearly in part going to be one of evidence. I see someone writing here. Okay, Louis has apparently lost access to his mic as well. Anyone either type or saying how you would approach this? It doesn't have to be all the detail. It's a pretty broad strokes that we're looking at here. It's basically the exercise we have on the arbitration part. So it's pretty general. I seem to have completely dumbfounded all of you. So you know what they're asking, but how would you start if you had to write an arbitration award on this? How would you get the information you need to do that?
I think we are overthinking the answer, because in my mind there's certain issues that's beyond the scope of arbitration, like the harassment and I think I read somewhere about sexual
harassment, right?
Harassment, and some of those things might end up in a criminal court.
So where it might become applicable is if you get some argument that takes a line similar to constructive dismissal, right? They said, look, I mean, we don't have this on the paper before us. I'm wildly speculating now, but if you have someone saying, look, there was a agreement, but it became impossible. This was used to lock us in, and then we were harassed, and that made it impossible to stay, and this was really the only way to protect ourselves. And in such a case, that argument might become relevant, though certainly the criminal court can be helpful. It takes a lot of the burden off you, but what do you do if the criminal court says we can't find beyond reasonable doubt, but you're sitting in an arbitration on your normal civil standard of balance of probabilities? So it's helpful, but it's not really a get out of jail free card.
And also to that, was there a meeting of minds? Was there consensus as you would do in contract law? Because it seems as if they were coerced into signing the documents, and which would lead to your point earlier that you said one will have to do or lead evidence as well.
Yes. So your problem here is the first thing is it's the very forms that has the covenant that has the arbitration clause. So your very first question is, can you actually arbitrate this? So you're actually going to probably have a point in limine to see if there's an arbitration. That might well go to court if someone if someone were to challenge that, were to challenge jurisdiction. This problem seems to assume that you would get the point where people would agree on jurisdiction, in which case you would move forward to the, okay, if the arbitration clause is there, then probably the covenant not to compete is also there. But as you said, you'd have all the questions about the pressure and the, you know, the fire on the one hand, the stick, and the pretty small, to be honest, but the carrot of the donuts and so on. You know, it's in any event undue influence, particularly in a group pressure type of way. There'd be all sorts of issues with the documents and privacy, but that wasn't even envisioned by this. And then so yeah, the answer really is going to be pretty high level. It's going to be, well, first I have to see that I can actually hear this matter. Then if I can hear it, I'll have to see if there's a binding contract. If it was, what do the parties say? What do they agree? So it clearly have to lead evidence. And then you've got the parties making the opening statements, limiting the problem to see what's in disagreement and what not. That will be the first step that will actually answer a lot of the questions which we don't have answers to now. And once it's limited, then you can either write an arbitration award if all the facts are really there. You just have to determine whether that was undue influence or not. But more likely, you're going to have to call witnesses and have cross-examination and re-examination and closing statements. So I agree. I think you are overthinking this. That's why I said earlier, this is really the basic arbitration exercise. And you can pretty much apply the same thinking you would apply to litigation, just with the specific changes like, you know, arbitration. There's no general jurisdiction like you might have in a high court, for example. Does that make sense?
Absolutely.
Okay. I think that's pretty much it. It's got us done quite early, but some of the exercises we couldn't do, and we did take the shorter lunch. Dodo, I don't know if this was the last class. I'm assuming there are some arrangements and stuff from your side still, instead of just dismissing everyone. But from the class perspective, I think we're done, though I will be around if people have questions for a bit still. I don't know if either Dodo or Advocate Malatsi or Nomsa has anything to say here.
I'm still here, Mr. Grovier. Maybe Dodo's gone to another class. From our side, it's only the issue of completing the assessments. I do believe that the date, Mr. Louis, has been clarified to, is it the 8th or the 12th? All the assessments must be completed, the online ones. So please make sure, please make sure that you guys complete them. And if there's anything, you can just email us. And we just also wait for the attendance register from Mr. Louis. And we must, I think you guys must expect your attendance certificate. Is it between 6 and 8 weeks from today?
No, I'm not going to give the attendance register. Everyone can redo the classes.
That would be terrible. Imagine. I'll
email Dodo in a bit, and then you guys' driver can just come pick it up from my office.
Yes, I think you should email it in the meantime while Dodo is making arrangement to come and collect the original register. Otherwise, all of the best to everyone regarding your practices. I know you're going to open practices and we'll meet one day.
Thanks, Advocate, and thanks for everyone as well.
Thank you so much.
If there's nothing else, as I said, I'll be around a bit if people have more questions or clarity that they want, or scenarios or anything like that. But if I don't get any questions for a while, I'll go, but I'm available for quite some time still if you do have questions or things you want to discuss. Thank you.
Thank you very much, sir.
Thank you, Mr. Grovier. So for next year, Do you recommend that we definitely find the venue for this class?
Yeah.
I mean, I made sure today that I don't move, I don't go to, I
Yeah.
just peep in other meetings, but I wanted to see how the breakaways and stuff like that would work out. It was
look,
not bad, obviously not optimal, but
Yeah.
certainly.
I think we did okay. And stuff like the labor, or if you do ethics or something like that, you can actually very easily, in many ways, that's actually easier remote than in person, because the students, can be in a comfortable place. They can have their notepads and everyone has their space and everything. But this specific one, it really is a workshop more than a lecture, the ADR. So I would have to say, I think we did okay, but yeah, I think we must push really hard to do this one in person. Even though it went okay, it's if we, like in a situation like this where we don't have an option, it's fine, we can do it. But I would, for this specific module, I wouldn't choose this if I have other options. Whereas for other modules, it's perfectly fine to do it remotely.
Yeah. We can only hope that the monkeypox is not going to attack us so that we continue working remotely. Oh my goodness. Yes, Mr. Ace?
Hello, Nimsa. I've a few questions about the online. I just want to clarify the online tests. I've mostly completed all of them, but I saw with personal injury claims, it does not reflect on the gradebook, and with all the other modules, the mark reflects on the gradebook. So I just want to know whether that mark then will only reflect on the 12th of August, or whether there's a
It is not actually assessed. I will find out from Dodo, because with personal injury claims, it's blended. So you had a class and you had to do the assessment. So with others which are graded, there were no classes at all. Am I correct? I think that's, if it's still working like that, things change every day. Do pardon me.
Yeah, it's just that one, and then the other one was LPAM. There was 10 online assessments.
Are they also graded for the LPAM?
They graded for the LPAM. So all the module ones are graded, except with LPAM. So it was personal injury claims and LPAM. So LPAM, there was 10 tests and quizzes, and only 8 of them are reflect on the gradebook. So I don't know whether they're only going to use those 8.
Oh, what? I'll find out from Dodo. I do. Maybe I should quickly call her in. Let me try and do that.
Hi, Advocate.
Hey, Dodo. Welcome again. So Mr. Ace wanted to know something about the assessments. Mr. Ace?
Yes, Dara, I just wanted to clarify with you regarding the test and quizzes with the online. The personal injury claims test that we did, it does not reflect in the gradebook. So I was wondering whether that will only be reflecting on the 12th of August, or
It does. Let me just quickly check. Just a sec. I want to check something because I did receive an email from you, and I went to the site. Think the problem maybe it's from your side because I can see here it's graded to all the candidates who completed the assessment.
Dodo, is personal injury claims also graded?
Yes, it's a multiple choice questions.
Yeah, I did the multiple
Yes.
choice.
Yes.
All I'm saying is in the
From your side under
yeah,
grade book.
an e-leader under grade book. Let me just check here. So under grade book it shows nothing.
Okay, no, just a sec.
Okay.
I want to check something, but you mustn't worry for that. I will check with the thingy, the leader department. It's not a stress. As long as you did it,
Yeah, no, I did
it's not
complete
gonna
it.
be a problem.
Okay.
Yeah, it's fine. I will respond to your email. I will check and see what is going on.
Okay, and that was the one, and then the other one I just also wanted to know was LPAM. There's 10 online tests and quizzes, but it only reflects 8 of them.
8. Yeah, no, it's
Is
fine.
that correct? So that's
Yes.
fine.
Yes.
Okay, no thanks. That's all I wanted to know.
Okay.
Okay, Dodo, just a quick confirmation. We are still doing the period 6 to 8 weeks before the certificates are issued, right?
No, it's no longer that because we are busy with the report now. Or hopefully in 3 weeks' time we will be done.
Oh,
yes.
even better.
Yeah, as long as they can complete their online assessment. But for those who completed, probably by next week or that other week, I'll be sending emails to them
to receive their certificate.
Yes.
Oh, nice.
So, any questions regarding with the e-leader?
Yes, on the online CSU NISA, there's no test and quizzes.
No, that one it's for your own noting.
I just want
Don't submit anything.
Thank you. Thanks.
Okay.
Dodo, Mr. Lewis is worried about his paycheck. When is it coming? Remember, he was a class rep. Are you gonna send him? Are you gonna send him his? Mr. Louis, you must submit your invoice to Lolot, Dodo, if you are still here.
Unfortunately, we don't have a budget.
Yeah,
But I'll
unfortunately.
talk
No,
to
but I think he
Nomsa.
left us. Yeah. It will be Mr. Rovia that we are expecting the invoice from. And are we still closing on the 7th? No?
7th.
7th of to be processed the same month.
Yes, please. Yeah. Even if you can send it to me today or tomorrow, the latest.
Okay, then all is well. Thank you so much, Mr. Rovia, and thank you, Dodo.
Thank you very much, Mr. Rovia. Thank you very much, Advocate. Thank you, everyone. All the best.
Dodo, I have a question just before you go. Would it be possible for the recordings of these 3 lectures to be made available to me as well, please? You know, I was having different technological things. I would like to hear it and just see to make sure, you know, to optimize for next year.
No problem, I'll do.
So if you can do that, that would be awesome. The other thing is on the we can discuss this separately at the stage, but on the ADR notes, I see they've been updated, but I think they got a bit disorganized in the updating. So the content seems to be updated, but there's a little bit 1 or 2 pages or sections that seem to be quite out of order. And a thing that's a little bit jarring is the foreword wasn't updated, and it's very dated. The foreword really places itself in time. So it might be sensible to just remove the foreword.
No, it's fine. If you don't mind, Mr. Javier, I'll send you the email address for Quality Assurance Department.
Yeah.
You can just send them an email.
Excellent. Thank you.
Okay. Thank you very much.
Okay. Thanks.
Dodo.
Yes.
Hi, my dear. There's a couple of outstanding evaluation links, I think, that needs to be sent to us as well. I don't know if that counts towards our attendance or not, or if it's just for your quality assurance, etc.
It's for the quality assurance, but I will send it today.
Okay, no problem. Thank you.
Okay, then you're welcome.
All right, bye, Mr. Rovia. We'll speak soon. And bye,
Okay.
everyone.
If there are no other questions, then it seems that's it. Thanks, everyone, and thanks, Advocate and Doro.
Thank you, thank you, thank you very much. Bye,
Bye.
guys.
Bye, Dudeki.
Mr. Kruvier, before we leave, you mentioned there's a couple of books. Where was it again? I made a note of it. There's a couple of books on negotiation, etc., that you can perhaps recommend us.